Law School Secret Series 12 Crimes Against Property and Review. Welcome! As always, be the change you wish to see in the world. Now, I'm going to briefly go over some law school ideals, and uh, we're going to discuss what we went over last time. I'm going to quickly skim through these. You can pause it if you want to look at anything. But basically, what we're going to discuss is crimes against the property. And crimes against the property can be divided into several categories. Here I've listed the main categories: larceny, robbery, embezzlement, false pretenses, receiving stolen property, arson, burglary, and extortion. But before I do that, I'm going to flip quickly through some of the prior areas that we covered just to discuss last time and not detail too much, but just let you know where you can go if you want to brush up on those skills. So like the last session was on crimes against the person. So if you look for 11 crimes against the person, you're going to be covering various categories. Particularly one of the big ones is homicide. And homicide is very, you want to learn all the nuances. Like, for example, when does human life begin and end? If you don't have a human life, you can't be convicted of one of the types of murder or homicide. So I went into detail, and you can probably get this on 11. And also there was a question as to when life ends. When is death occurring? This is another nuance. In 11, a few examples were given of differing arguments for when death occurred. When is it when the heart stops beating? We put you on life support. When the brain stops having brain waves. So these are questions you might want to know. And of course, we discussed the year and a day review, and we discussed the classifications of homicide. For example, a soldier going off at war can't be prosecuted for murder unless he uses war crimes, and that would be done in international courts such as the Nuremberg trials. So, for example, you've got justifiable, excusable, and criminal. And I went into the categories of those and detailed them for you. And then we went through the classifications of homicide, the elements of murder, the degrees of murder, deadly weapon doctrine, and common law forms of malice for murder, etc., etc. And so then we also discussed some of the defenses: general intent versus specific intent, transferred intent, causation. Now, with causation, it was on series 6 and 7 for details on that. Accomplice liability, common law, misdemeanors, types of crimes, felonies, um, you know, defenses for homicide, and the list goes on. Defensive property, rarely can you have homicide and use the excuse defensive property because it's never a defense. Um, you'll learn with the law there's always going to be exceptions to these rules. So anyhow, these are some of the defenses, and let's get over to where we want to start. So we're starting with crimes against the property, and we're going to start with larceny. So what is larceny? Larceny is the unlawful taking and carrying away or exportation of another's personal property without consent, by trespass, and with the intent to permanently deprive. The slightest movement will satisfy the carrying away requirement. Concurrence must also occur between the intent and the action of the mens rea and the acts rea. So, now robbery is larceny plus assault. And this requires a wrongful taking of the personal property of another from the other's person or presence by force or threat or immediate physical harm, with the intent to permanently deprive him of it. At common law, it's the trespassers taking an asportation of the personal property of another with the intent to permanently deprive the owner of possession of the property. Statutory larceny changes the verbiage a bit, and instead of trespassory taking, it might say unlawful taking of the property. So there's going to be slight different words. And so with burglary at common law, it's the breaking and entering of a dwelling of another at night with the intent to commit a felony therein. Now, burglary modernly is the trespassory unlawful entrance of any structure with intent to commit a crime, and it doesn't need to be in the nighttime, and it doesn't have to be a dwelling. And there's also the curtilage, and it can be any enclosed area. So now you've got arson. That's another crime against property. At common law, it's the malicious burning of the dwelling of another. Modernly, it's going to include other things similar to the burglary. Now, embezzlement is the fraudulent intent, the fraudulent conversion of another's property, personal property, by one in lawful possession. The embezzler always has lawful possession. Now, this is a crime that is statutory, typically, and the definitions do vary from state to state. Typically, if it's an employment case where they're accused of embezzlement, it would be a high-level employee. Otherwise, if it's somebody like, a low-level secretary, an office employee, and they take home some tape and paper and some supplies from the work, or they skim some money off of, expense sheets or something like that, that would be considered theft and larceny. They're not going to give them a charge of embezzlement. So usually a higher level person like a CEO would be accused of embezzlement. Now note, this is a picture of Bernie Madoff in the background. Bernie Madoff is a special Ponzi scheme federal case. I actually studied this for white collar crime in my master's degree and wrote a paper on him. But he, in fact, did obtain property and funds through fraud. But it's kind of like, they didn't charge him with that. They charged him with something else. But anyhow, so false pretenses. Anyway, I just didn't want to mislead you in thinking wrong. It's just a picture of somebody out on bail. Okay, so false pretenses tends to be a statutory crime, and it varies from state to state. Generally, the defendant must have intended to get another person to convey title to their property by misrepresentations of facts, either through omissions or fraudulent misrepresentations about the property. In some cases, it's not necessary to obtain actual title, rather the crime of misrepresentation of facts to obtain the property. An example of this is the Frank versus State car trade. In this case, the guy traded in the car. It wasn't titled to them, and then they didn't pay for the other car that was used as collateral, but he didn't really have title. And so that was considered false pretenses. Now, larceny by trick is similar, and it's obtaining possession but not title through false pretenses. And this is where you're going to have different states or statutes. Interpretations might vary a bit. So anyhow, a person that gains possession and not title of property through false representations, the property is taken through consent by deception. This is where a person consents to forfeit their property through another person, intentionally deceiving them about this. For example, if a person asks you to borrow a book, but they never intend to return the book, and let's say it's like a $150 rare book. They say, "Can I borrow this?" I'm like, "Okay." and then they keep the book, and they never intended to turn it, that would be larceny by trick, the way I understand it. Now, if you see UK law where this idea originated, look at the case Rex versus Pear. Now, under modern statutes, larceny by trick and false pretenses are indistinct. In other words, the overlap is enough that they don't consider them distinct crimes. Again, you're going to have a varying law depending on the jurisdiction. Okay, so continuing trespass is another way of taking a of a type of larceny or illegal. So, for example, it's not exactly larceny because they didn't intend at the time of taking the property to permanently deprive the person. Rather, let's say your neighbor goes into your garage, they want to borrow your lawnmower. They intend to return it, and then they decide, hey, this is a fabulous lawnmower, and it's so great, I'm going to keep it. So they took the property, and they did not intend at the time, but then they changed their mind about keeping it. That would be a continuing trespass. Now, abandoned or mislaid property. A lot of people say finders keepers. Well, that's not exactly true. Finders are not keepers, okay? If you find a wallet on the ground, or if someone finds a wallet on the ground, the person's ID is in it, and there's a thick wad of cash, and then the person says, I'm going to keep this cash, and then I'm just going to drop the wallet back down and walk away, or I'm going to keep this cash, and then I'm going to turn the wallet in with the license in it and the ID and the credit cards, because they could probably trace that, but I'm going to say, look, I found this on the ground, but there was no cash in it. At this point, they would be guilty of larceny. So it's, it's something, it's like you need to be on your honor, because you can be charged with crimes. So anyway, basically they have to act as a reasonable person and make a reasonable effort to return it. Bring it into the police station. If you're at a library, something, bring it into the library. And so the finder's got to make reasonable efforts. And there's a distinction between abandoned property and mislaid property. And these cases have been argued in different courts. If you want to look up the nuances, go ahead. I might expand on this, but I don't know. Let's see. Okay, so let's go to extortion or blackmail. Now, at common law, extortion is the corrupt collection of a fee by a public official. Nowadays, modernly or statutory, it's been expanded and it includes it includes other people besides public officials, anybody, in a position where they can have something over on you. So let's say the extortion, the way it's written into the statutes, will vary by jurisdiction, of course. But it would satisfy the elements of a threat, and usually it's not the same, like as robbery would be distinguished. Robbery, excuse me. Rather, they might have threats of emotional harm. For example, they might threaten to manufacture evidence against you, to ruin your reputation, or accuse you of a crime, or impute some deformity or disgrace. That's sometimes the language used in different laws. It is the malicious threatening of another, and the way to prove malice does not have to be, seriously deliberating, but rather it can be kind of recklessly threatening or impulsively another in order to obtain property. For example, let's say a person's going through a divorce. Now, this is a civil case, but they could actually be tried as criminal. Let's say husband and wife are getting divorced. The husband does not want to pay the wife alimony. He didn't really want a divorce. He gets a protective order on him because he's physically and emotionally abusive. He's had a 2-year restraining order or something, and then after 2 years they go to get divorced. But in the meantime, he hires a private detective and gets photographs of the wife making out with her new boyfriend. And he threatens to expose her as a whore and blackmail her with the pictures, and says, look, I'm going to take these photos and this information I got from this person, and if you don't sign over the real estate to me and give up your right to alimony, um, and give me custody of the kids, then I'm gonna um, I'm gonna I'm gonna expose you as a prostitute. And of course, he's got more than one picture because she broke up with one boyfriend over the 2 year period and got another one. He's gonna say, I'm gonna say you're prostituting money. But anyway, so extortion is generally punished as a felony, and it's like the courts are case by case. Okay, so receiving stolen property is another crime. And at common law, receiving stolen property in England, it laid the foundation for modern statutes, but typically it was very hard to prove as a crime and prove intent and everything. But modernly, they're a lot looser with that. And for example, if somebody buys a piece of property off the street from somebody, and or even if they get it from a pawn shop and they get it at a really low price, um, they could have to forfeit the property. Another thing is, like, let's say, here's a perfect example. You are going through the parking lot over to Best Buy or some big store that sells computers and other electronic equipment, and they say, come here. I've got a stack of MacBook Pros here. I'm going to give you for $20 each. They're brand new. They're in the box. They're still sealed in plastic. And you're like, well, what's wrong with them? How did you get them? Oh, I had a business. It's a going out of business sale. I'm trying to liquidate the property, he says. So you give them $20 and you take the MacBook Pro. And you say, hey, I'll take 3. This is a great deal. Maybe I can give them as gifts. So you give them $60 and you get 3 of them, and then you put them in your car, and you were going into the store to buy one of those, something less expensive, and then the cops come out and they say, hey, you're guilty of receiving stolen property. And then he says, no, I'm not guilty of stolen property. I didn't know it was stolen. And the cop says, according to the statute in this state, a reasonable person would know if there's a price that different that it's stolen. So anyhow, the person is found guilty of receiving stolen property, a crime, because a reasonable person would have known that, according to their statute. Okay, so next time we're going to talk about the SAC crimes, which are inchoate crimes, and here are the references. And as always, thank you so much, and please like, share, and subscribe. If you click on the little bell up at the corner there, you can get notified when I upload new videos. Thanks again. Take care.